más de la academia en reforzar el cumplimiento de los fines que la ley ya asigna, considerando su obligación ineludible el destacar la responsabilidad internacional de la Federación de Rusia ante la invasión armada del Estado de Ucrania, así como la flagrante violación del derecho internacional, de los derechos humanos y del derecho internacional humanitario por esta acción. Hoy todos estamos unidos en la protección de los derechos humanos en Ucrania, como una manifestación de la responsabilidad que en un mundo nuevo aspiramos todos, que se desarrolle de tal manera que eventos como el que está sucediendo no vuelvan a suceder o limiten su ocasión en las distintas etapas de la historia humana. Pero nadie mejor para ilustrarnos acerca del derecho humanitario que internacional humanitario que el doctor Goldman. Los dejo para una breve palabra de presentación con el académico Carlos Ayala para luego compartir esta presentación, esta importante presentación del profesor Goldman.
Julio, si puedes apagar el micrófono, por favor. Gracias. Y quiero, al darle la bienvenida al profesor Robert Goldman, decirle que estamos muy agradecidos por el tiempo que va a dedicar en esta conferencia y después, por supuesto, en la etapa de preguntas, en la etapa de comentarios que pueda haber. La actividad, como ustedes han visto, además está acompañada y coesponsoreada por el grupo de academias que ha mencionado el presidente, academias de América Latina con las cuales ya hemos venido realizando algunos actos, y quiero darle especial gracias a los académicos que han estado en contacto con esas academias, pues en primer lugar al doctor Badel y por supuesto también al doctor Romero Musi. Al mismo tiempo quiero darle las gracias a la doctora Mariana Escolaro por la traducción o la interpretación simultánea que va a hacer, y para eso los que están escuchando, pues abajo donde dice interpretación en el Zoom o en el YouTube Interpretation, pueden colocarlo para la conferencia que va a ser dictada en inglés, los que quieran escucharla en español con esa traducción. Yo le pedí al profesor Goldman que fuera particularmente pedagógico, como si prácticamente estuviera dando una clase a alumnos de él en la Facultad de Derecho que se estén iniciando en el tema, porque es un tema que no es harto conocido y que es importante pues que todos los juristas tengan una base de formación e información para los que quieran seguir profundizando. Para presentar al profesor Goldman, pues diré algunas pocas cosas de su vasto currículum. Es profesor de Derecho y Scholar Louis James en el Washington College of Law, que es la Facultad de Derecho de American University en la ciudad de Washington, D.C., y además es codirector del Centro para el Derecho Internacional de los Derechos Humanos y Derecho Humanitario, y director en la facultad de la Oficina de Investigación sobre Crímenes de Guerra. Fue electo presidente de la Comisión Internacional de Juristas en el año 2018, pero ha servido desde el 2008 en esa comisión. Del año 71 al 74 fue decano assistant dean, decano asistente y profesor asistente en esa facultad de Derecho, y además trabajó anteriormente como asociado en el despacho Arnold & Porter en la ciudad de Washington, D.C. Desde el año 76 entonces regresó a ser profesor asociado en la Facultad de Derecho y decano encargado. Además de que a partir del año 81 fue director de los programas de estudios legales internacionales. Luego sirvió como encargado del decanato, como hemos dicho, y además, por supuesto, es miembro del Bar, del Colegio de Abogados del Distrito de Columbia y del estado de Virginia, en cuya universidad obtuvo su grado de abogado. Además, ha sido miembro de la American Society of International Law y estuvo en su consejo ejecutivo, y además es editor de el libro sobre aspectos procesales del derecho internacional. El profesor Goldman además enseña, escribe sobre temas del terrorismo, el derecho internacional de los derechos humanos y el derecho internacional humanitario. Es autor de varios libros que menciona en su currículum. Fue miembro durante 8 años en 2 periodos de la Comisión Interamericana de Derechos Humanos. Allí nos conocimos en el año 96, en enero del 96 por primera vez. Y dentro de la comisión fue relator precisamente para temas como las personas desplazadas internas, y en países como Colombia y Argentina que tuvieron temas que ver con precisamente derechos humanos y derecho internacional humanitario. En el año 2004 al 2006 fue un experto independiente nombrado por Naciones Unidas por el Alto Comisionado de Derechos Humanos como experto independiente para la protección de derechos humanos en materias relacionadas con el terrorismo. Y en el año 2005 fue nombrado uno de los 8 miembros eminent jurists del panel sobre terrorismo y contraterrorismo, al mismo tiempo de que fue uno de los autores principales del grupo en el 2009 para evaluar los daños y las acciones urgentes que se requerían, cubriendo aproximadamente 40 países afectados, y todo esto con ocasión de los temas de Estado de Derecho y contraterrorismo y las políticas públicas que se adoptaron después del 11 de septiembre en los ataques a los Estados Unidos. Fue nombrado por el gobierno de los Estados Unidos como presidente de una comisión internacional de juristas sobre el tema de administración de justicia en el Perú en 1993, y el año siguiente presidió un equipo de abogados bajo los auspicios de la American Society of International Law y el International Human Rights Law Group, que preparó un estudio al requerimiento del representante de Naciones Unidas para personas desplazadas, Francis Deng, y tuvo un rol preponderante en la preparación de los principios sobre personas desplazadas, Guiding Principles on International Displacement. Bueno, no quiero quitar más tiempo en la presentación de quien, además de un gran jurista, es un buen amigo, es un buen compañero y amigo por los últimos casi 30 años, y además especialista en la materia, y quien quiero que sepan que habla español con un acento sureño, entre uruguayo, donde vivió, y argentino, donde admira y ha tenido que ir mucho, pero por la especialidad de la materia nos pidió poder dictarla en inglés. Por favor, adelante, Bob, la sala es tuya.
Bueno, unas palabras en castellano. Quisiera agradecer a los organizadores de esta conferencia y sobre todo a vos, Carlos, por la invitación. Y mira, dada la complejidad, la terminología compleja del tema que me tocan a mí el día de hoy de desarrollar, no voy a hablar en el idioma de los seres humanos, castellano. Yo voy a hablar en inglés. Entonces, perdóname, pero vamos así. Entonces, estamos listos para la batalla, Carlos, ¿ok? Okay. Thank you very much. Now, before discussing the very serious and ongoing crimes committed by Russian forces in Ukraine, I think it is really important to have a basic understanding of the law which governs that conflict, and that is international humanitarian law. IHL essentially does two things. It governs the conduct of hostilities, and it seeks to protect persons who do not or no longer directly participate in the fighting. IHL is also known as the law of war or the law of armed conflict. IHL is the product of centuries of warfare, from which certain rules governing the conduct of hostilities have developed. And the principles of restraint in the waging of war can be found in early Judeo-Christian, Oriental, Hindu, and Islamic teaching. For example, in the 4th century BC, Sun Tzu, in his classic work, The Art of War, admonished combatants to care for the wounded and prisoners of war. He also warned against committing atrocities as they infuriated the enemy and increased his fighting ability, rather than paralyzing them with fear. And experienced military planners have come to realize that violence and destruction, which are superfluous to securing a military advantage, are not only immoral and wasteful of resources, but are also counterproductive to the attainment of the political objectives for which military force is used. Early rules of warfare were generally issued in the form of orders by sovereigns to their own troops. Over time, similar limitations imposed by other sovereigns became regarded as rules binding on them all. These rules became known as the jus in bello, or the law of war. Now, it is important to distinguish the jus in bello from the jus ad bellum, or justification for the resort to war. The doctrine of just war, the jus ad bellum, was first formulated as a theological rather than a legal concept. The doctrine was developed by Catholic theologians who accepted the reality that Christian rulers would go to war. While the doctrine mostly dealt with conditions justifying the resort to war, it also stipulated that a just war should not be fought without restraint, but rather must conform to the principles of discrimination and proportion. These two principles, as I will note later, have gradually become rules of customary law, binding on the parties to all armed conflicts. Now, it should be noted that modern IHL is not concerned with the legality of the use of force by states. This important issue today is exclusively governed by the United Nations Charter and state practice thereunder, and is a subject for adjudication by an international tribunal, such as the International Court of Justice or the International Criminal Court. The modern law of armed conflict has two branches, which are commonly referred to as Hague Law and Geneva Law. Hague Law consists of rules regulating methods and means of warfare, that is, the jus in bello. In the late 19th and early 20th centuries, states began to codify these rules in treaties. But it was not until 1977 that the law governing the conduct of armed conflicts was updated to reflect the realities and the increasing lethality of modern warfare. Geneva law sets forth rules for the protection of victims of armed conflicts and is the humanitarian component of IHL. These rules, which are of more recent origin, were largely the product of the efforts of the International Committee of the Red Cross, which was established in 1863 in Switzerland. In the aftermath of World War II, states approved the four 1949 Geneva Conventions, which protect the wounded, sick, and shipwrecked members of armed forces, prisoners of war, and civilians. As these conventions have been ratified by virtually every state in the world, they have universal acceptance and application. In 1977, the Geneva Conventions were updated and further developed in two new treaties. Additional Protocol 1, applicable to international armed conflicts, and Additional Protocol 2, which applies to non-international armed conflicts. In addition to these agreements, other sources of IHL include instruments that prohibit the use of certain weapons, such as chemical and biological agents, as well as prohibiting certain military tactics or seeking to protect certain categories of persons and objects. Finally, there is a large body of customary IHL not codified in these treaties, which is binding on all states. Before discussing the notion of armed conflict, I think it's important to note that IHL does not apply to so-called internal tensions and disturbances. Examples of such situations are riots, mass demonstrations, and isolated and sporadic acts of violence, during which the military frequently assists the police in maintaining order. Serious situations of internal tensions are frequently the precursors of armed conflict or can occur during armed conflict. Typically, such situations have one or more of the following characteristics: declaration of states of siege or emergency, large-scale arrests, large numbers of political prisoners, disappearances, ill treatment of detainees, and the suspension of many fundamental rights, particularly judicial guarantees. Some recent examples of such situations include the Arab Spring, where mass demonstrations led to the fall of the governments in Egypt and Tunisia in 2011, and recent pro-democracy demonstrations in Thailand, Myanmar, and Hong Kong. I should also note that such tensions and disturbances have occurred over time in Venezuela, in Nicaragua, and in Chile. International humanitarian law divides conflicts into two kinds: international armed conflicts and non-international armed conflicts. International armed conflicts are those waged between states. Recent examples of such conflicts are the 1982 war between the United Kingdom and Argentina in the South Atlantic over the Falklands, Malvinas Islands, the invasion of Afghanistan by the United States in 2001, the wars between Iraq, the US, and its coalition partners in 1992 and 2002, and the ongoing hostilities between Russia and Ukraine, which commenced in 2014. International armed conflicts are governed by the entirety of the law of war. That is the four 1949 Geneva Conventions, in the case of Ukraine and Russia, Additional Protocol 1, as well as rules of customary international law. Now, whereas international armed conflicts entail hostilities between two or more states, a non-international armed conflict involves fighting between a state's armed forces and armed opposition groups, non-state actors such as rebels or insurgents, or between such groups, generally occurring within the territory of a particular state. Non-international armed conflicts have occurred with far more frequency than international armed conflicts since the end of World War II. In addition, such conflicts have become increasingly more complex, both in terms of the parties involved and their territorial scope. And reflecting this reality, the International Committee of the Red Cross has identified at least 7 different factual scenarios entailing NIACs. The most traditional kind of NIAC is that where a state's armed forces fight against a non-state actor, generally within the territory. And such examples of these in our hemisphere were the armed conflicts in El Salvador in the 1980s, in Peru in the 1990s, in the recently concluded hostilities in Colombia between the FARC and the governmental armed forces. Now, once an armed conflict begins, it is important to understand that IHL applies equally to and binds all the warring parties, whatever the nature of the armed conflict, international or non-international. Accordingly, in a NIAC situation, non-international armed conflict, both the state's armed forces and those of the armed non-state actors have the same rights and obligations. It is a common misconception that IHL applies only in areas of active combat. To the contrary, IHL applies throughout the territory of all the warring states in an international armed conflict, and in the case of a NIAC, within the territory under the control of the parties involved, whether or not actual fighting is taking place. Now, during situations of armed conflict, IHL divides all persons into two categories, civilians and combatants. In an international armed conflict, civilians are all persons who are not members of the armed forces of the states involved in that conflict. Similarly, in a NIAC, civilians comprise all persons who are not members of the state's armed forces or the armed forces of the organized armed opposition groups. Under the law of war, civilians enjoy the highest level of protection. They cannot be lawfully attacked unless they directly participate in hostilities. Direct participation in hostilities is a very complex subject, which has been studied extensively by the International Committee of the Red Cross. And what I can tell you is there is disagreement among the militaries of the world of what activities constitute direct participation. But there is agreement that when a civilian assumes the role of a combatant and undertakes armed or unarmed activities which active duties members of armed forces undertake, that person is directly participating in hostilities. It is important to understand that while civilians forfeit their immunity from attack while they are directly participating in hostilities, they nonetheless retain their status as civilians. And unlike combatants, once civilians cease their hostile acts, they regain immunity from attack. Although civilians cannot be intentionally attacked, international humanitarian law envisions that they may be killed or injured, incidental to an attack against a lawful military target. While such civilian casualties are indeed regrettable, such collateral damage, if not excessive, does not violate IHL, and I will say something more about this in just a moment. Now, one of the major differences between the law governing international and non-international armed conflicts is that there is no de jure prisoner of war status in a NIAC. In an international armed conflict, prisoners of war captured by the adversary enjoy immunity from prosecution under the domestic law of their captor for their lawful acts of war. This is not the case in a non-international armed conflict. The government is free to try enemy, that is members of insurgent rebel groups, for each and every one of their hostile acts, even if those acts otherwise comply with the law of war. Unlike civilians, combatants in all armed conflicts are subject to direct attack at all times until they are hors de combat. A combatant is hors de combat when captured by or expresses an intention to surrender to the enemy, or when rendered unconscious or incapacitated by wounds or sickness, and therefore is incapable of engaging in hostile acts. All such persons become non-combatants and as such can no longer be lawfully attacked. Combatants do, however, have certain protections under IHL. The warring parties cannot use weapons that cause superfluous injury and suffering, such as exploding bullets. They are protected also against the use of chemical and biological weapons and blinding laser weapons. IHL also prohibits the use of poisoned weapons, the denial of quarter, treacherous killings, and the murder and mistreatment of prisoners of war. Now, there are two basic principles that underlie the law of armed conflict. One is the principle of military necessity, and the other is the principle of humanity. The principle of military necessity justifies those measures of regulated violence, not forbidden by international law, which are indispensable for securing the prompt submission of the enemy with the least possible expenditure of economic or human resources. Thus, military necessity cannot legally be invoked to justify or to excuse a violation of a specific prohibitory rule. The principle of humanity complements and limits the doctrine of military necessity. This principle forbids the infliction of suffering, injury, or destruction not actually necessary for achieving a military advantage. It is this principle that confirms the immunity of civilians and the civilian population from being intentionally attacked. Taken together, these principles require, in all armed conflicts, that the warring parties must always distinguish between civilians and combatants, and civilian objects and military objectives, and only direct their attacks against combatants and military objectives. The drafters of Additional Protocol 1 in the 1970s were very aware that advances in weaponry in the complex nature of modern warfare were increasingly placing the civilian population at heightened risk of harm. They therefore sought to update the rules governing means and methods of warfare so as to enhance the protection of civilians against the effects of hostilities. In Article 51, for example, in order to achieve this, there is now for the first time an express prohibition of indiscriminate attacks. And this is extremely relevant to the ongoing hostilities in the Ukraine today. Indiscriminate attacks are, among others, those which are not directed at a specific military target, that is, intentionally targeting an object or a person entitled to protection. Another kind of indiscriminate attack is that which uses a weapon which cannot be directed at a specific military target, or is of such a nature to strike civilians and civilian and military objectives without any distinction. And this has been a hallmark of the conduct of hostilities by the Russians against cities throughout the Ukraine. The use of things such as cluster munitions, the vacuum-style bombs, and so forth, that cannot reasonably be used and directed against a specific military target. And what is also important in Additional Protocol 1 is that it codifies for the first time the rule of proportionality as it relates to civilian casualties. And it speaks about an attack which foreseeably would cause incidental loss of civilian life and damage to civilian objects that would be excessive in relation to the anticipated military advantage from the destruction, capture, or neutralization of the military objective. And to this extent, Article 57 now imposes very clear-cut obligations on terms of precautions that the various warring parties must take in order to spare civilians. One of those things which the attacker must do is if you are going to attack a military object that is located in an urban environment, you must choose that weapon at your disposal that will avoid or at the very least minimize foreseeable collateral damage to civilians. In this sense, the Russians do possess what are known as smart weapons, precision-guided munitions, and either they have chosen not to use these or they have done so extremely selectively. It is very important to understand, for instance, that there is a duty on the part of the attacker to refrain from launching an attack which it reasonably can foresee that is going to cause excessive collateral damage. Proceeding with such an attack is a flagrant war crime today, and so forth. And as I will say later, that the commanders are under a very stringent duty in order to prevent and punish war crimes committed by their subordinates. Now, finally, it is worth noting that while the law governing international armed conflicts is far more detailed and developed than it is for non-international armed conflicts, it is very clear today that any method and means of warfare that are prohibited in an international armed conflict would be similarly prohibited in a non-international armed conflict. Now, during international armed conflicts, such as that ongoing in Ukraine, the four 1949 Geneva Conventions, as supplemented by Protocol 1, provide detailed rights and safeguards to certain categories of persons expressly protected under these instruments, namely the wounded and sick and shipwrecked, prisoners of war, and civilians. These persons are entitled to respect for the lives and physical and mental integrity and must be treated humanely. Protected persons cannot be the object of reprisals, nor can they renounce the rights and protection afforded them under the conventions. The conventions require also that the wounded, sick, and shipwrecked members of the armed forces must be collected and receive the medical care and attention required by their condition, and that medical personnel, supplies, hospitals, and ambulances must be protected from attack, and that prisoners of war and civilians detained by the enemy must be treated humanely. Now, the Geneva Conventions oblige states to disseminate IHL to its armed forces and to the public at large. The conventions similarly require states to prevent and punish IHL violations, which in turn requires states engaged in armed conflict to exercise effective command and control by superiors over their troops. States are also required to enact laws to criminalize grave breaches of the conventions. These are serious war crimes committed against persons or property protected by these instruments. Grave breaches are also crimes of universal jurisdiction, entailing the individual criminal responsibility of the perpetrator. Such breaches under the conventions include willful killing, torture, inhuman treatment, causing great suffering and serious injury to body and health. These and other serious violations of Additional Protocol 1 are today within the subject matter jurisdiction of the International Criminal Court. As noted, IHL contemplates a regime of penal sanctions at the domestic and international level to repress and punish serious violations of the law. As such, and unlike human rights law, neither the Geneva Conventions nor their additional protocols establish an individual complaint procedure available to victims of IHL violations. Not surprisingly, these victims in recent years have turned with increasing frequency to international and regional human rights treaty bodies, such as the Inter-American Commission on Human Rights and the European Court of Human Rights, which have procedures whereby the victims can seek a remedy for violation of their rights occurring during armed conflict. This raises the question of the complex relationship between IHL and human rights law, which I will touch on briefly. Now, although IHL and human rights law share a common purpose of upholding life and dignity and are complementary legal regimes, they have developed separately and have different legal frameworks and scope of application. There are important differences between these two bodies of law. Specifically, human rights law applies at all times, including during armed conflicts, while IHL only applies during recognized situations of armed conflict. Human rights law permits states to derogate many rights during armed conflict. In contrast, IHL rules are not derogable, and violations by one of the warring parties does not free the other side from its duty to respect the law. Importantly, human rights law de jure binds only states and their agents, such as armed forces during armed conflicts, and does not impose the same legal obligation on non-state actors such as rebels. In contrast, IHL binds and applies equally to all the parties in all armed conflicts, including non-state actors. And whereas human rights law establishes state responsibility for violations, IHL establishes individual criminal responsibility for serious violations, such as human rights law. In essence, human rights law, notwithstanding its application during armed conflict, is essentially peacetime law and was not conceived to govern the conduct of warfare. Specifically, human rights law contains no rules defining or distinguishing civilians from combatants or civilian objects from military objectives. Human rights law is also silent on the very important issue of when civilians lose immunity from attack or when a civilian object becomes a military objective. These important matters, in my view, are exclusively the province of IHL. Properly viewed during armed conflict, human rights law should be regarded as the lex generalis, and IHL, particularly the jus in bello, as the lex specialis during armed conflict situations. As I have noted, human rights treaty bodies have received in recent years numerous complaints alleging violations of protected rights, especially the right to life, to liberty, and to property occurring during armed conflicts. Virtually all these treaty bodies have found their respective instruments to apply extraterritorially, even in situations of armed conflict. But it is important to understand that these treaty bodies have no common approach on how IHL and human rights law interrelate when states are engaged for example, in a NIAC within its own territory, much less when they are involved in a NIAC or an international armed conflict abroad. This is still very much a work in progress. Finally, it should be noted that these human rights treaty bodies have jurisdiction to decide only cases involving claimed rights violations attributable to a state and its agents. Comparable violations by non-state actors, such as rebels during a non-international armed conflict, unless those violations are plausibly attributable to the state itself, are not justiciable by these human rights bodies. This situation, unfortunately, leaves a gap in protection to persons whose rights have been violated during hostilities by non-state actors. There are 4 kinds of crimes that Russia has committed and continues to commit in the Ukraine. The first is the crime of aggression. Article 4.2 of the Charter, as many of you know, prohibits one state from using armed force against another state, with 2 notable exceptions. The first is when the Security Council, under Chapter 7 of the Charter, authorizes the use of force, such as it did in 1992, permitting states to undertake the liberation of Kuwait from Iraqi occupation and putative annexation. The second exception is found in Article 51 of the Charter that permits a state to exercise individual and collective self-defense in response to an armed attack. Neither exception applies to Russia's invasion and occupation of Ukraine, which began not 4 months ago, but in 2014. Russia's hostile acts against Ukraine are, I believe strongly, in fact and law, a textbook example of aggression, as that term is understood and codified in the statute of the International Criminal Court, of the International Criminal Court. And as head of state, who is responsible for planning and carrying out these operations together with his high command, Vladimir Putin should be accountable for this egregious crime. Belarus, similarly, is guilty of aggression against Ukraine, as it willingly permitted its territory to be used by Russia to launch its most recent invasion of Ukraine. The second kind of serious crimes that have been committed are war crimes. We see daily, all of us, in real time, the damage that Russian military has inflicted on Ukraine, and particularly on its civilian population. There is no question, I believe, that the Russian military has intentionally and deliberately targeted civilians and civilian objects. And these include hospitals, stores, schools, churches, and cultural sites. They have utterly failed to take the minimum precautions when undertaking attacks on military objectives in civilian areas to choose the weapon that will avoid or minimize collateral damage. This is effectively total warfare, and it should not come as any surprise to anyone who knows Soviet military doctrine, which has been embraced by the Russians. Just see what the Russians did to Grozny in the war on Chechnya. They leveled it, and they did the same in Syria when they leveled Aleppo. The other crime that Russia has been committing in Ukraine involves crimes against humanity. And these are crimes that are committed as part of a widespread or systematic attack directed at a civilian population. knowingly doing so. Such crimes include murder, forcible transfer of a population, persecution against identifiable groups of civilians, rape and other forms of sexual violence, and inhuman acts of a similar character that are intended to cause great suffering or serious bodily injury or to mental or physical health. This is being very well documented today. We know that thousands of civilians have already died. In many cases, it appears in villages and so forth that were de facto occupied by Russian troops outside of Kiev. Once they have retreated, there have been over 400 examples of persons who appear to have been summarily executed, for instance, and tortured while in the hands of the Soviet military. And the last crime, and perhaps the most difficult to prosecute and prove, is that of genocide. Now, the notion of genocide requires a very specific intent to destroy all or part of a national, ethnic, racial, or religious group. Genocide includes not only killing, but also causing serious bodily or mental harm to members of the group, or deliberately inflicting on the group conditions calculated to bring about its physical destruction in whole or part. Vladimir Putin has stated, prior to the outbreak of these hostilities, that Ukraine is not a nation, that the Ukrainians really do not have a national identity. Not only has he tried to dismiss the notion of a Ukrainian identity, but effectively through the action of his military on the ground, he is seeking to destroy that identity. He is transferring children forcibly, apparently, to Russia, as well as I understand it, over 100,000 citizens of Ukraine. And this in and of itself is a violation of the law of war. Now, many of you know, and I will conclude on this and be delighted to take questions or comments. Many of you know Russia is not a party to the statute of the International Criminal Court, and neither at the outbreak of the hostilities was Ukraine. However, Ukraine has consented to an investigation of crimes within the jurisdiction of the International Criminal Court to be investigated. And indeed, the prosecutor of the ICC, after 40-some countries have also formally referred the situation in the Ukraine to the prosecutor, has been investigating the commission of crimes by the Russians and possibly those by Ukrainian forces within Ukrainian territory. The simple fact is that it is going to be extremely difficult for the International Criminal Court to hold Putin and the High Command responsible, accountable for these atrocity crimes as well as aggression. It is not foreseeable, so long as Putin remains head of government, head of state, that he will extradite himself or deliver himself to The Hague, assuming that charges are brought. There is the potential, however, for the exercise by individual states of universal jurisdiction over the perpetrators of various kinds of atrocity crimes. Recently, for instance, Germany prosecuted 2 members of the Syrian armed forces for having perpetrated torture against persons under their custody and control in the armed conflict that is ongoing in Syria. And so it could very well be that individual members of the Russian armed forces will could potentially, if they leave Russia, be subject to prosecution and the like. And I should also mention that Ukraine has filed before the European Court of Human Rights, and I suspect individuals will be filing both before the European Court of Human Rights and the Human Rights Committee, complaints alleging violations of the right to life and so forth, torture by Russia. And I would not be surprised to see other states possibly filing interstate complaints. To this extent, human rights law is indeed relevant. It will not establish individual criminal responsibility of the perpetrator, but it can establish the responsibility of the state, because many of the war crimes that have been intentionally committed by Russian forces are coextensive with human rights violations that are guaranteed, that is, of rights that are guaranteed under the European Convention and the Covenant on Civil and Political Rights, to which Russia is a state party. Thank you very much for your attention, and I would be delighted to hear comments or questions.
Muchas gracias al profesor Robert Goldman. Creo que la secretaria puede retomar el control para dar la palabra, y entiendo que el presidente Julio Rodríguez quería brevemente decir algo antes de que comiencen las preguntas y comentarios. Entonces dejo, por favor, en control del orden de las preguntas y del debate a nuestra secretaria, la doctora Cecilia Sosa.
Bueno, en primer lugar, de verdad, nos sentimos muy complacidos por esta conferencia, porque ha hecho una presentación que vincula tantos sistemas de protección de derechos humanos como el derecho internacional humanitario, el derecho internacional de los derechos humanos. Es decir, nos ha verdaderamente planteado un cuadro apasionante a mi manera de ver, con esta situación vinculado obviamente al tema de la responsabilidad de los estados y las responsabilidades individuales. Él había solicitado el derecho de palabra el académico Rafael Badel Madrid.
Yo quisiera antes de que empezara, buenas tardes a todos, quisiera antes que empezara el ciclo de preguntas, primero que todo darle las gracias al profesor Robert Goldman por una exposición que ha sintetizado, ¿verdad?, en muy poco tiempo relativamente, ¿no?, toda lo que es el corazón de la problemática de lo que implica la violación de derechos humanos a raíz de una invasión de un país por parte de otro país. Quisiera igualmente agradecer a los académicos iberoamericanos que han estado presentes, muy especial agradecimiento al doctor Augusto Trujillo y al doctor Ernesto Cavalier Franco por habernos acompañado en el día de hoy, a los demás académicos y presidentes de academias, directores de academias y académicos iberoamericanos que nos han acompañado además en el día de hoy. Y quisiera empezar con las palabras, el derecho de palabra, para responder a las preguntas de cada uno de ustedes. Muchas gracias por su participación en el día de hoy, y vuelvo a reiterarle al doctor Goldman mi agradecimiento y el de la Academia Venezolana de Ciencias Políticas y Sociales por su interesante intervención.
Tiene el derecho de palabra el académico Rafael Badel. El micrófono, por favor.
Gracias, el micrófono. Gracias, secretaria. Gracias, presidente. Buenos días a todos. Mi intervención en primer lugar para darle las gracias al profesor Robert Goldman por su muy interesante conferencia sobre los crímenes de guerra, la invasión de Rusia a Ucrania, y resaltar lo muy bien documentada que está su conferencia la mañana de hoy, y en especial me llamó mucho la atención la interrelación, interrelationship between humanitarian law and human rights law. Esa parte me ha parecido extraordinaria. Me parece que ha sido muy interesante para nosotros aquí en la academia haber podido oír al profesor Robert Goldman en este tema que lamentablemente nos va a tener a todos pendientes por mucho tiempo. También agradecer a Carlos Ayala por la organización de este evento, por la extraordinaria idea, y en especial a los académicos de las academias hermanas que se han unido, agradecer la generosidad que tuvieron de ellos de respaldar este evento. Y quizás lo más importante de mi intervención es sencillamente prever que debemos hacer otras reuniones en relación a este tema. Ya vemos la densidad de las palabras del profesor Robert Goldman desde el punto de vista jurídico, pero también hemos leído otras consideraciones. Somos Academia de Ciencias Jurídicas, pero también políticas y sociales, desde los puntos de vista de la nueva geopolítica que causa esta guerra por parte de Rusia, esta invasión en Ucrania, de cómo la alianza entre Estados Unidos, Inglaterra, los 27 países de la Comunidad Europea, Japón, Corea del Sur, otros países asiáticos y Australia, se ha convertido en una alianza mucho más sólida en momentos precisamente en que casi se disolvía esa alianza producto de la salida de Inglaterra de la Comunidad Europea y de la amenaza de Estados Unidos de dejar la OTAN. De manera que hoy hay una alianza pro-occidente, pro-democracia, que parece que es más fuerte, mientras que por el contrario, Rusia parece más aislada, parece más sola, parece más débil y en ese sentido más responsable por las atrocidades que ha cometido. Sencillamente y vehementemente doy las gracias al profesor Robert Goldman por su muy interesante conferencia y creo que todos aquí en la academia vamos a querer que nos visite con frecuencia para seguir estudiando este tema. Muchísimas gracias.
Quisiera invitar a los académicos que quieran hacer alguna pregunta, que si pueden colocar la mano, como lo ha hecho muy bien el amigo Ernesto Cavalier Franco, quien tiene la palabra. Si le pueden reactivar el audio, por favor.
Muchas gracias, doctora Cecilia Sosa y secretaria de esta reunión, de esta conferencia. Y mis agradecimientos a los organizadores de esta excelente presentación, esta excelente conferencia que hemos tenido el gusto de escuchar. Mis felicitaciones al doctor Robert Goldman por esa excelente presentación que deja pues también sobre el tapete muchas inquietudes. Una de ellas, si me permite, el doctor Goldman, es preguntarle sobre la aplicación de la resolución de 2005 de las Naciones Unidas sobre la responsabilidad de proteger. Es una resolución adoptada en vista del genocidio y que el presidente Zelensky resaltó en algunas de sus presentaciones que estaba ocurriendo en Ucrania específicamente. Y esa resolución es una resolución muy grave, digamos que puede generar unas consecuencias muy graves porque genera la responsabilidad de todos los estados, prácticamente de las Naciones Unidas, de proteger a un pueblo contra el genocidio. Entonces, pues, presenta una disyuntiva difícil políticamente de graves consecuencias eventualmente. Y quería preguntarle al doctor Goldman cómo ve ese asunto. Muchas gracias.
Doctor Goldman, ¿cómo prefiere usted? ¿Reunimos todas las inquietudes o prefiere ir respondiendo pregunta por pregunta?
Perhaps that I could address this. The issue of the responsibility to protect and so forth, which I'm very familiar with, because much of what was done in developing the normative framework for internally displaced people was based on that. They did not have any kind of regime. unlike refugees and so forth. There is very specific law, more specific than a resolution on the responsibility to protect under IHL. Specifically, Additional Protocol 1 imposes very strict obligations and so forth, beyond what we have seen historically, on the parties to armed conflicts to mitigate suffering and so forth of individuals. The idea that individuals and civilians and so forth, if they do not have sufficient food, if they do not have sufficient medical attention and so forth, that a state such as Russia must accept an offer, for instance, by the International Committee of the Red Cross to permit them to undertake this kind of assistance and also to protect these victims of the armed conflict. And we have all seen that until the last several days, attempts, for instance, in Mariupol to evacuate civilians, many of whom have very serious wounds. It is my understanding some have gangrene. Some of them are children who have been born, literally born underground and have never seen daylight. And those mothers need medical attention. The Russians refuse to do this. And only under the pressure of the Secretary General, working through and with the ICRC, are we beginning to see some kind of implementation of what are an obligation of a besieging party and so forth should do. We have very specific law. And again, this law is not being implemented as it should be.
Doctor Goldman, profesor, a mí me gustaría hacerle una pregunta como académica y siguiendo un poco el desarrollo de su conferencia. Usted nos ha hecho un vínculo bastante estrecho entre el derecho internacional humanitario y el tema de la guerra. Pareciera que tienen una vinculación muy estrecha uno y otro. Y le quería preguntar dos cosas. Primero, en el caso de la actual guerra de Ucrania, esto que uno oye permanentemente, que los Estados Unidos, que Inglaterra, que Francia, están trasladando material bélico a Ucrania, están enviando equipos militares. ¿Esto los convierte en beligerantes o esto es algo que está permitido? Y lo segundo que me gustaría preguntarle es cómo se prevé para el derecho internacional humanitario la opción de una guerra nuclear. ¿Eso está planificado? ¿Eso está estipulado? ¿O eso todavía está no tiene una regulación vinculada precisamente porque es una destrucción absoluta y ya el derecho internacional humanitario es muy difícil de separar las distintas situaciones que se den? Quería oírlo en ese enfoque.
Gracias, Cecilia. With respect to the first question, in order for let's put it this way, the fact that NATO is supplying weapons and so forth to Ukraine at its request so that it can defend itself does not make these NATO countries up to this point, parties to the conflict. It gives a huge international dimension. There is no question about that. But many of you will recall that when Nicaragua brought a case against the United States for its support of the contra-revolutionary forces and so forth. The Nicaraguan government had argued at that time that the acts that were undertaken and so forth by the Nicaraguan Contras were attributable to the United States, and hence Nicaragua was involved in an international armed conflict with the United States. You might recall that the court rejected that argument under the effective control test. And they said, even though a state may train, provide financial, military resources, and so forth, that is insufficient to make that state a party to the conflict in the sense of attributing those acts. You know, as President Biden has said, and I think President Biden has really shown brilliant leadership in terms of getting the West and framing this as this is a battle today against essentially democratic forces, Ukraine that seeks its own self-determination, to be able to join Western institutions or to choose to be a neutral country. That is their choice, arrayed against the autocracy of Putin and his minions and so forth. And that this international aspect, as of now, does not create an international armed conflict as between the NATO member states and the US, and Russia. Now, let's suppose that at some point that NATO decides that they will impose, as was done in Iraq after in the first Gulf War, a no-fly zone. That would internationalize. That would make, by having NATO countries, the United States flying and so forth, or the introduction of NATO forces to fight on the side of the Ukraine, that clearly is going to internationalize the conflict. And these countries then become involved in a war with Russia, which is what the United States has sought to avoid, largely because of your second question. Russia has a military which has shown the world is undisciplined and incapable of fighting in accordance with the laws of war. And they have threatened, both Putin and Lavrov have threatened implicitly that if their backs are pushed against the wall, they could use nuclear weapons. This is a complex issue. And as many of you might know, there was an advisory opinion by the International Court of Justice years ago, brought by the General Assembly, over the legality of the threat or the use of nuclear weapons by particular states. And in a somewhat convoluted opinion and so forth, the court did not find that there was sufficient opinio juris to say that the abstention by the principal nuclear powers gave rise to a restriction or prohibition on the use of those nuclear weapons. The Geneva Conventions, and particularly Additional Protocol 1, do not regulate the use of nuclear weapons. You never would have gotten the nuclear powers in the midst of the Vietnam War in the 1970s to have agreed to subject nuclear weapons to the regulation of that new instrument. Their position was the United States, Russia, and other nuclear powers are engaged in separate negotiations and in separate treaties. Now, that said, it is very difficult to envision, with what we know about nuclear weapons and the effects of nuclear weapons, that you could use a nuclear weapon, most particularly in or near an urban environment that would not be par excellence indiscriminate and a war crime. It is conceivable that a small yield tactical nuclear weapon could conceivably be used in an uninhabitable place. But why would you do that? And so I think that the fact is any power that would dare to use nuclear weapons and so forth, this would be not only devastating, but quite frankly, would have to invite a response by the NATO powers, because a taboo which has not been seen since 1945 would have been broken. Thank you.
Gracias, profesor Goldman. Tiene la palabra el académico Carlos Ayala, que tiene la manito levantada. Por favor.
Muchas gracias, Cecilia. Bueno, yo también para sumarme, como vamos ya terminando la actividad, a darle las gracias a nuestro amigo Bob Goldman por la brillante exposición que ha hecho y bueno, inclusive pedirle que si tiene algunas notas que ha preparado para esta exposición que en inglés inclusive que nos las haga llegar para publicarlas en nuestro boletín de la academia. Yo quisiera hacerle una pregunta última muy precisa al profesor Goldman, que es la siguiente. Hemos visto el ataque a hospitales, el ataque a escuelas, el ataque a residencias civiles, lo cual conforme a lo que usted nos ha explicado son claramente crímenes de guerra, porque no son combatientes, son civiles. Ahora, la pregunta es la siguiente: ¿qué pasa si en alguna instalación hay civiles no combatientes, pero llegan militares y esos militares están desde esa instalación civil no solamente apertrechados con sus armas, sino eventualmente hasta entrando en combate con militares rusos? O sea, ¿es legítimo que en ese caso los rusos ataquen indiscriminadamente? ¿O cómo sería la regla de combate que aplicaría allí para no cometer un crimen de guerra? Muchas gracias, Bob.
Okay. Well, that's a very good question. It involves the following considerations. In the dynamics of armed conflict, an object which is a civilian object can lose its protection and become a military objective in a short period of time. For example, it may very well be, let's say the Ukrainians decided to put command and control in the basement of a school because they thought it was secure. One, that's something they should not do, because by putting command and control within a school, it has converted that school into a military objective. But this does not mean that you can invariably attack it. If during the day you do your target intelligence and you realize that there are 800 children in that school with their teachers who are civilian, before you attack this, you must do a calculus of the foreseeable collateral damage, that is the foreseeable deaths and injuries to those civilians, when weighed against the importance of the military advantage that you could get from its destruction. And most people would say to knock out command and control and to kill or wound 800 civilians would be excessive and wrong. And this would require, for instance, in updating your intelligence to say, school may be over at 6 o'clock at night. If the command and control is still there, and there is only a custodian, for instance, in the building cleaning, then you could go forward and attack and to destroy that. And that wouldn't be a violation of the law of war. Let me give you a concrete example, Carlos. In the Second Gulf War, when the United States and its coalition determined, very questionably, on bad intelligence and so forth, that it was going to invade Iraq, and eventually it would remove Saddam and establish an occupation. The United States was going to begin a campaign in a certain way. But they got intelligence that Saddam and his top generals were going to be at a restaurant on a certain evening and so forth. One, given the role that Saddam had with the military, which I would say was very much akin to Putin's role with his own military. He's the commander-in-chief, but he is in charge. He is giving orders. To be able to so-called decapitate the military leadership at the beginning of a war is a really major strategic advantage, apart from obviously affecting the morale and so forth of that country's troops. The United States made a decision to attack. Apparently, Saddam had left the restaurant several minutes before. As a result of the attack, the restaurant was destroyed, and there were numerous civilians who were killed. I don't know of any responsible organization that claimed that was a war crime. In other words, these civilians were unfortunately at the wrong place at the wrong time. That this was the restaurant became a military target subject to attack by virtue of the presence of active duty, high-ranking military personnel in the commander-in-chief and so forth. And so this is highly situational. Each one of these examples, and I do this in class all the time, will take a slightly different situation, and what it requires at the end of the day is a good faith calculus on the part of the party that is going to launch the attack, that it will avoid or minimize civilian casualties. In other words, it's going to adhere to the law of war. And so you've raised a very, very real life question that occurs quite frequently.
Thank you.
Yeah.
Muchas gracias, profesor Goldman, por su respuesta. ¿Hay alguna otra pregunta? De lo contrario, bueno, pasaríamos a la palabra al presidente Julio Rodríguez para despedir este encuentro tan fructífero desde el punto de vista de un tema que nos va a acompañar durante un buen tiempo, y creo que este ha sido un excelente abreboca para esa finalidad. Muchas gracias.
Bueno, muchas gracias otra vez al profesor Goldman, a Carlos Ayala por habernos acompañado a este evento, a todos los que nos han acompañado, los organizadores del evento, a la doctora Cecilia Sosa, que ha actuado como moderadora de alguna manera de este evento. Y bueno, es una preocupación que sigue en la mente de todos nosotros, no solamente de las academias, de la academia venezolana, sino de todas las academias iberoamericanas y mundiales, muchas de ellas en virtud de todo el comunicado y todo lo que se ha dicho al respecto. Y quisiera finalizar este acto, darle unas buenas tardes a todos y desearle que tengan un feliz día, y ha terminado el acto y ha terminado la sesión de la academia del día de hoy. Que tengan todos